Like having a letter of support or a testimonial that just says, I am the CEO of XYZ org and I can confirm that Mrs. Y has had an important influence on our company, period. Like
Right,
that letter is not very helpful.
right.
And like a letter from a US government official that's 2 sentences is not very helpful. What we want to look for, I think, when we're doing these is think about people who, can really describe your work well and in detail, and they know why it was important.
Good morning, everybody. My name is Joaquin Rosales. I'm in-house counsel here for Visa Franchise. I'm delighted to introduce you to Andrew Smith from Boundless. Andrew Smith is a great attorney that we work with in what we call our top talent visas, EB-1, EB-2 NIW, and O1s. He has an extensive experience in these type of visas. We're going to dive into a couple of topics, not only about, what these different visas are, and what kind of people typically apply for these type of visas, but the process itself. And I want to thank you, Andrew, for giving us your time this morning to speak about these visas. And how you doing? How's everything?
Good. Thank you, Joaquin. It's great to be here, and I'm super excited about talking about, what I spend all my time doing, which is thinking and writing about these, top talent visas.
Absolutely. Well, we appreciate you, giving us some of your time to explain some of these visas. So, in general, I wanted to sort of, make distinctions, right? Typically, let's focus first on so the EB-1 and the EB-2, right? We can give a little bit of a background. I mean, I know a lot of people, typically know their criteria that are involved in these two visas. They tend to be very similar, although on the EB-1 side, there's, sort of more enumerated criteria than the EB-2 NIW, but they seem to have like crossovers, right? And a lot of people sort of don't see sort of the distinction. So, what would you say it's the biggest distinction that you would want to point out in terms of these two visas?
I would say there are two kind of really key considerations here. One is the kind of discretion and level of adjudication from USCS. Certainly, especially recently, we've seen increasing kind of difficulty and increased requests for evidence in EB-2 NIWs. But, the EB-1 does really remain a sort of higher level of achievement and needing to see that argument that you are at the top of the field. EB-2 NIW, as we must show that your work is nationally important and that you are well qualified to pursue that work, there is obviously an indication that you should be somebody experienced, distinguished, accomplished in your field. But there is more leeway as the candidate for the visa and for us as attorney practitioners to present that in a way that doesn't require us to sort of show the same level of evidence. And I suppose another key distinction I would want to mention is for EB-1, while we obviously want to show that you are an expert in your field, and I think as a matter of implied argument, that comes outside of your employer, we want to show that you are impacting the field at large. There is a sense in EB-1A that you can be an incredible server hardware engineer, and you speak at conferences, you've published tons of books, and that's perfectly fine. And that's true for NIW, but there is this kind of nugget that we have to dig out about the national broad importance of the work that I think is not necessarily a challenge for NIW, but it does make the way that we position EB-2 NIW different. And for some candidates, I think, they may find that both visas are an attractive option. And in other situations, that aspect of the national interest waiver may sort of determine what our strategy would be in sort of guiding them towards that eventual green card.
Right. So, going on what you just explained, I mean, it's important to, make that distinction in terms of the wording, right? The language that the visa requires, right? You're dealing with the extraordinary when it comes to the EB-1, right? And then typically it's advanced degree, and then exceptional, right? Abilities when it comes to the EB-2 NIW. But, me as an attorney, and I want to get your take on this, right? Would you say that there's some situations in which you would find a person that could perhaps be qualified as an extraordinary, has extraordinary abilities, and yet that wouldn't particularly translate to an EB-2 NIW, even though it's beneath the EB-1, and like the distinction among the word extraordinary and exceptional, right? Obviously, there's this distinction where extraordinary is at a higher level, right? And then you have, at a second tier level, sort of the exceptional ability. Would you say there's situations in which a person could be sort of not qualified as extraordinary, but perhaps due to the national interest side of the EB-2 NIW, they might not qualify. So it's kind of like, why is it that I can qualify for the quote unquote first one, right, but not the second one, right? Could you
Yeah,
just elaborate a little bit on that?
that's a great a question, and I think a really timely one because with perm delays and kind of the increasing backlog of the Department of Labor process, a lot of Silicon Valley and other tech firms are their corporate councils are kind of filing NIWs willy nilly for everyone.
Yeah.
And, I think when I started my immigration practice, there was a sense that with a good attorney and strong arguments, you could get most NIWs approved if the client was qualified in their field. And I think, we've seen more recently in adjudication that USCIS is pushing on this national interest part. And so I would say if you are an extremely talented senior product manager or machine learning engineer, but one who works sort of like internally on products and projects, as you're thinking about building out your profile, like honestly, it might not be unusual for some of these folks that the reaching that extraordinary threshold would actually be an easier, maybe not easier, but a more logical thing to shoot for than trying to build out a sort of argument about the national importance of their work where we are at the mercy of a reasonable immigration officer sort of accepting that what they do inside their employer is impactful on the field. And I think, there are some non ridiculous arguments that one can make about sort of how internal product management or machine learning work like trickles down and affects the field, but it's a more challenging argument for the attorney to make. And I think you're at the mercy of the immigration officer's kind of understanding of that first prong of the national interest waiver and the national importance and substantial merit. And while it's certainly possible, I think as you very rightly said, there might be these situations where not to say that extraordinary might be an easier kind of label to
Right.
shoot for, but it
Right.
may
Right.
make more sense from the immigration perspective to angle your green card strategy that way.
Right. That's really interesting that you bring that up, about you're at the mercy of the immigration agents, and that's something that I wanted to touch upon. So I mean, it is sort of, there's a degree, right, of subjectivity, right, and they get a lot of sort of leeway to make these sort of decisions based on the information that they get. Me myself as an attorney, immigration attorney as well, and I'm in all sorts of attorney chats, Facebook groups and all that. And I've seen a lot of sort of discussion, right? A lot of debate among attorneys in terms of how much evidence do you really want to put forth. Some of them tend to think, you're really kind of wasting your time if you're going to put, an application worth of 1,000 pages worth of evidence when they have minimal amounts of time to review the stuff. It's better if you're just more simplistic. You have more like, sort of like a targeted approach, right? Where you want to make your argument, where you stand in terms of your experience as to whether is it better to have, not I don't want to say less evidence, but just not overwhelm, right, the agent with so much information, and just be more sort of targeted in your arguments, and just lay out what you think are the strongest arguments for the particular criteria for that particular client? Or do you think that's just better that you throw out everything to the agent, and then that way at least you can say, hey, I did the best that I could to that extent, right?
That's a fantastic and $1 million question. I think if I had a perfect answer to that, I would, you know, have a 100% approval rate with USCIS. But, I do think it's an interesting question. And what I have learned from my experience, and I think my preferred approach is what I would kind of think of as like the Goldilocks approach. So, somewhere just right in the middle. I understand the argument for submitting a really, really concise petition. And I think it has some merit. My concern, though, is that, if one errs too far on the side of this sort of brief and concise petition, that the officer may issue an RFE sort of saying, well, you didn't document, like you just submitted the first page of a publication, but you didn't submit anything else about that publication.
Right.
And, on the other hand, if we write a 120-page legal brief and we have 900 pages of evidence
Right.
and documentation,
Right.
is there, sometimes a hopeful chance that like the officer is impressed by the size of the kind of petition on their desk and they just approve it because they want to sort of, not read it? I know that I think some practitioners and some clients hope that that's the case. Because I sort of feel slightly unsure about both of those extreme approaches, I try to kind of fall a little bit in the middle, and I think there's two strategic reasons for that. One is based on kind of those two extremes we just talked about, in the sense that don't really want to like write a brief that's so concise that the officer thinks, the candidate must not be qualified. But we also don't want to overwhelm them when our best guess is that most immigration officers have 15 to 30 minutes to review each of these.
Right.
So what I sometimes like to do is sort of include most, if not all, of the documentation and aim for a sort of more concise, or at least more pared back on the legal brief, because that's where they're going to kind of focus. And then they can go to the evidence if they want to. And I think this has two advantages. One, if, it's sort of like plays to both the officer that's going to read this in 5 minutes and the officer that's going to spend 30 or 45 minutes, and they have everything that they need to see there. I think the other thing is, if we do receive an RFE, and it's important to remember that requests for evidence, unfortunately, are sort of a little bit of a matter of luck in EB-1, in particular adjudication. Maybe 20-25% of cases might get them regardless of the strength of the case.
Right.
This sort of approach of holding a little bit back in our evidence quiver, so to speak, means that we have something to come back at the officer with, whether that's because there was evidence in the evidence that packet that we touched on but didn't fully explore, or even potentially we saved a few media articles or saved a few scholarly publications back. It gives us something to push back with, so that we're not just responding to a request for evidence with a sort of slightly legalized regurgitation of the original brief. And I think that that's given, me, in my experience, that's given us the optimal way of sort of handling this sort of conundrum of how much evidence to present USCIS
Yeah,
with.
that's extremely interesting, and like I said, I mean, there's two different sort of sides that are constantly battling that out. I've heard a ton of attorneys in these chats saying, "What are you doing? You're just wasting paper." The other side is like, "What are you doing? You're not being doing your duty right to your client on submitting as much evidence as possible." But it's certainly, I tend to agree with you that so as most things in life, right in the middle is typically the best way to approach these things. I wanted to make this a more of an advanced discussion about the visas for people who already know the criterias. A lot of people already know, you know, remuneration, membership in distinguished associations, publications, right? They need special licensing, contributions, right, to your industry, critical role, all the sort of the main topics, right, that you see and are pretty similar across both visas. But if you were to I guess pick which criteria or number of criterias that you see tend to have the stronger sort of argumentation, right? The stronger sort of push and weight for an application when an adjudicating officer is reviewing it. Which ones of those criteria that I mentioned do you think are best? Not to say that one, as we read it right in the regulations, it doesn't say that one is weighs heavier than the other one, but experience speaks louder than anything that it's written in a policy manual or something like that, right? So
Yeah.
in your experience, what would you say you've seen are the criteria that hit the hardest?
Yeah, and that's a great question. I would caveat my response with just saying that whatever I think are the strongest criteria, it's always possible that we're going to see an RFP that gives a
Right.
like
Right.
really like criterion not met.
Right.
So but I do think over my experience with these, and particularly recently working with sort of technical engineering business professionals on these EB-1 cases, I sort of see four criteria that build what I like to think of as sort of like the foundation of these cases. And one of those is critical role. For critical role, if you are in a senior kind of level in your field, you have been doing this for a decade or so, getting testimonials from current or former employers, from industry experts, sort of affirming that and this doesn't mean that you literally like led the direction of a huge multinational, but we want to show that the candidate was involved in projects where their role on that project affected the organization, the company's sort of success, whether internal or external. I've found that I think when properly presented with strong letters, like this is, a really solid criterion for EB-1 and O-1 clients. Second is, I think, original contributions of major significance. This one is sort of an interesting criterion because I actually know that some of my clients, some other attorneys, like feel mixed about even including this if a client doesn't have sort of patents or some kind of other commercialized like trademark or something. And I do think that's a valid concern. I think the interesting thing about this criterion, though, and why I think it hits hard, sort of in your phrasing, is for better or worse, I find that USCIS, in my experience, treats this criteria as a little bit of like a mini EB-1A in the whole.
Yeah.
And so I think there is a sense that if we can't at least argue that you've made innovative, significant contributions in your field, there are, and again, I want to be clear that I don't think this is not the like valid interpretation, but so a lot of immigration officers, in my experience, seem to treat that as you cannot be at the top of the field if you've not made innovative contributions. So sometimes we have to, I think, come up with clever and creative ways to argue truthfully why these like contributions of our clients, of the candidate, has sort of impacted the field and not just their employer, whether that's because of a process that was adopted, the kind of impact that a mega employer might have trickles down sort of outside of its internal processes, et cetera. But that, I think, is another kind of key criterion. And then I guess others would be high salary. I do find that there is a little bit of a split on this in terms of like in EB-1 cases where we might be applying for like a business leader or an entrepreneur. I find that this category can really, I think, hit with a lot of impact. For more of a typical like engineer or a academic EB-1 profile,
Right.
might be a little bit more challenging to overcome the officer's skepticism of like what a high salary is. But I do think when appropriate, this can be a really hard hitting sort of piece of evidence as to why the candidate is risen to the top of their field.
And it makes sense, right? So, if your industry is related to, money, right, finances and all that, I mean, if you're demonstrating and having evidence that demonstrates that you're doing extremely well and getting paid really well, so that makes a lot of sense. And going back to the original contributions, just a word itself, right? Like that sentence, when people read that out and they go to USCIS, website, and they read out the criteria, that seems to be extremely intimidating, right? You say an original contributions to your industry, to your field, and it seems to like, obviously we're attorneys, and we know what we can argue, right, and how creative we can get. But like to the layman, to everybody who will just read it, it seems extremely intimidating, and to hint that you have to do something like revolutionary, right, in your industry in order to be counted, right? So I guess my question to you is, how can you explain? How can we explain to basically our audience that it doesn't have to be that revolutionary? I mean, it can be just like you said, within your company, and I guess going a little bit deeper into the letters of recommendation that are so important to sort of evident have the evidence to put forth this argument. What have you found that is the best thing? Is it typically just sort of upper management or executives that have worked with the candidate, or people who have worked at the same level of the candidate in some projects, or maybe some outsiders, maybe some companies that have hired that particular company where the applicant was working on? Where do you see sort of like the best sort of arguments in there?
Sure. Just to step back to the first part, and I agree with you about the intimidating part of original contributions. I think when I'm talking to potential EB-1 clients, this is most often the criterion that people will tell me, like they think they had to be an academic to do EB-1A because of this criterion. And, I think it's helpful perhaps to sort of take the criteria in its words, like bit by bit. So basically, original, we need to show that the candidate did something new, innovative, not revolutionary,
Right.
innovative. And I think there is a key difference there. And, oftentimes we have to remind the immigration officer of that. And then that that this contribution is somehow impactful in their field. Again, to echo you, not revolutionary, just,
Right.
impactful, widely important. And one of the ways we can document this that's really critical for the EB-1 process, as well as O1, is through these letters of recommendation, these testimonials. Your question is a fantastic one about this sort of what level do we want to get these from? And I think this is a really important strategic conversation to have with your attorney, with legal counsel, because, a lot of times I get asked like, oh, should I work really hard to get a letter from the CEO of my company? I think my answer to that is always, it depends. Obviously, having somebody who is at a really high level and is obviously an expert in their field is going to, of course, be helpful and supportive to your EB-1 case. However, if you are, an incredibly important AI engineer at a, Silicon Valley firm, some of these firms are huge, and you could have an incredible impact on your company and be like incredibly distinguished, and the CEO will probably not have much idea what you actually do. And
Right.
so like having a letter of support or a testimonial that just says, I am the CEO of XYZ org, and I can confirm that Mrs. Y has had an important influence on our company, period. Like
Right.
that letter is not very helpful.
Right.
And like a letter from a US government official that's 2 sentences is not very helpful. What we want to look for, I think, when we're doing these is think about people who, can really describe your work well and in detail, and they know why it was important. And then, of course, like the more senior, the more expert they are, the better. But like, I don't see a particular artificial line where, like, for example, we couldn't use a manager, but we could only use someone whose title was director. Like, I think that in all situations, there's going to be times where getting a director or a vice president is well suited to your EB-1. And there's going to be other times where like a senior manager or a manager is also perfectly placed to attest to, whether it's your innovative contributions or critical role. So, I think that picking the right mix of those is important. And then, obviously, to follow up to your point about outsiders, I often think that these sort of outside letters are definitely helpful. for EB-1 applications. A lot of candidates are sort of scared about this process, and I think it's an important discussion to have, and sort of like how we can present a sort of outside pulled back lens view of someone's work. And there isn't an artificial kind of requirement or number of these, but they do give a sort of helpful perspective on someone who the candidate hasn't worked with directly, who can give a sort of more high level but more from the field at large kind of vision of why their work has been impactful.
I want to ask you a little bit about, I think that a lot of people, and rightly so. I know that, the Biden administration, pushed, directives pertaining to STEM, right, applicants. But I wanted to just sort of, veer it off a little bit from those, right, from the STEMs, even though, they're obviously very important. But if you can just give us examples of successful clients that are not particularly in STEM, right? And you've
Yeah.
seen them get approved either for EB-2 NIWs or EB-1. So some examples of not your typical, okay, you're a great engineer, okay, you're
Yeah.
a great tech guy.
Yeah. And I think that's a great point. On the one hand, a lot of STEM people think that like EB-1 is impossible for them. And I think on the other hand, a lot of folks feel like it's limited to STEM, particularly with this sort of, as you very rightly mentioned, increased rollout of focus on sort of AI, STEM things and immigration. I think it's definitely worth remembering that these criteria really apply to anyone who can show they are at the top of their field. And for EB-1, I've worked successfully with journalists, artists, uh, in addition to sort of people who might be sort of on the fringes of STEM in like marketing or social media, that's sort of on the edge between STEM and business, or even sort of, pure business entrepreneurs, fintech investors. All of these are sort of all strong options. Obviously, for the EB-2 NIW, I think researchers and academic fields have almost a sort of inherent advantage for NIWs, but this is one where I've seen successful cases for even like a linguist, an
Wow.
architect.
Right.
So people who worked on sustainable design. There are, I think, a lot of solid arguments that can be made for a lot of fields, that will fall well into these visa categories.
That's great. So let me ask you just one last question before I move on to a different topic, a little bit more in depth in terms of the EB-2 and IW. So me and you know this, but for the public, right? There's something called retrogression. So perhaps it doesn't really make any sense whatsoever to do premium processing for, say, an EB-2 and IW right now, right? Because that category is retrogressed. But let's just assume that there's no retrogression, meaning for our audience, that means that there's visas available. If you're approved right now, you'll have the ability to basically, finish, the process, whether it be at the consulate or if you're inside of the United States, you can, do an adjustment status. What's your take on some people that say, doing a premium process might just simply give you an RFE because a lot of agents are sort of overwhelmed, and that buys them time to sort of work on their huge amounts of folders that they got on their desk,
Yeah.
and it's just not really worth it. And it's probably just best that you save yourself $2,800 when it comes to that. Is there any merit to that argument? What do you think about that?
I think it's an interesting question. I think I do not have sort of like the statistical data to make like a kind of firm, conclusive advice. I would say I and other immigration attorneys that I correspond with and follow, I think there is definitely a sort of sense that premium processing can be more likely to result in an RFE, whether that's for EB-1 or NIW. I would also say, that I try to be understanding of my clients and potential candidates. And, when the potential of an approved whether it's EB-2 or EB-1 might kind of give them a leg up in the retrogression. A lot of people are just kind of not willing to wait that long period of time. And I know in my practice, I still see really strong approval rates for cases filed directly with premium processing. But I would also, in a nod to your question, and say that I do, without any conclusive proof, get the sense that sometimes we get RFEs at the kind of last minute of a premium processing fee that period, that don't necessarily have a lot of detail.
Yeah, it's like a boilerplate
Yeah.
response. It's like there's copying and pasting stuff just to throw it
And
out.
one strategic option that I have worked with some of my clients on, and I don't speak to it as a source of truth, but is filing a case in regular processing and then upgrading it a few months later.
Right.
Seems to, for whatever reason, have a slightly higher chance of success.
Strategically, yeah, that makes absolute sense. That makes perfect sense. Well, thank you for that. So I want to just jump in now. We've talked a lot about EB-1. I want to jump in a little bit more into the EB-2 NIW, because there's a sense out there, and I've had this discussion in other videos, that there's a lot of people that think that if you just have an advanced degree, you're going to be sort of approved. And I think that unfortunately, there's a lot of firms out there pushing this idea that so long as you have an advanced degree, it's in the bag, essentially, so to say, right? And I wanted to get your take on that, and then also on specifically to focus on what's asked for from USCIS in terms of not only national interest, but then also the proposed endeavor. It seems like a lot of people don't really comprehend how much of a pushback, USCIS, we get from USCIS when it comes to your proposed endeavor. What are you going to be doing in here? So if you can just elaborate a little bit in your experience when it comes to that.
Great point. And I think just to tie it back, this is, I think, a reason why rise in sort of anyone in STEM with a master's degree sort of just feeling like they can automatically apply for NIW is, I think, leading to some higher pushback on that. And it's important to remember that is not sufficient. The NIW national interest waiver is sort of, as I like to think of it, it's very simple, but also very complex. So that, we have three prongs that we need to show, and they're, the first that relate to this proposed endeavor. And the first is that your proposed endeavor has national importance and substantial merit. Now, as you rightly highlighted, this idea of the proposed endeavor is not clear. And, the legal decision matter of Donisar makes it a little clearer, but not helpful entirely. What I like to think of it as is sort of your proposed project. And oftentimes, I will have my potential NIW clients sort of tell me either what they're planning to do in the US or give me a description of their work that doesn't, revolve. Their employer can be a part of it. There's no problem with your employment being a part of your proposed endeavor, but sort of if you had to draw a narrative thread from your education all the way through to what you're doing now, like what would you call what you have been working on and will continue working on? And there's also a few ways we can document this. I know some attorneys sometimes like to include like an actual statement from the NIW petitioner. Sometimes, we'll just describe that in the legal brief. My own take is that it's generally not worth including a sort of some kind of personal statement from the applicant, because it may just muddy the waters or give USCIS something to latch onto unless they specifically request that in an RFE, and that's different. But it's important to sort of work to frame your proposed project. And again, the best way I can kind of advise is to think of this as like what you do, but in as broad a way as possible. And, USCIS is very clear that the proposed project doesn't even need to be successful for a like you don't need to show that you're going to succeed. So if you wanted to start a business as an entrepreneur, or you're going to say that you're leveraging your autonomous vehicle experience, but there's no guarantee that autonomous vehicles are going to ever like work out. None of these are a problem for the NIW. We just need to show sort of that there is a project, an endeavor that you are working towards, and that and that we can describe that.
Perfect. Thank you for that, and that's very very good. And I think our audience is gaining a wealth of knowledge from your discussion of these topics that I think like as I stated before, I think a lot of people are educated on the criterias, but they don't see these nuances, and that was the point of this whole conversation. I wanted to get into sort of like the head of attorneys like yourself who have seen a ton of cases, and they can see trends and what may be difficult and what perceptions might not be quite true. So the public is aware of the process and these visas themselves. So we're gonna move on a little bit. I wanted to talk about I guess what I call the baby EB-1, which is the O1, right? We know that, the O1, obviously me and you they have pretty much the same, criteria, right? But I wanted to, give us just first an overall explanation of what the O1 visa is, and then dive in a little bit into, as we just explained, there's very similar, if not the same criteria that is taken into consideration when it comes to this visa, right? Sort of the level of evidence or strength needed in comparison to the EB-1 when it comes to the O1A.
Yeah, great question. Just to start us, the O1 is an employment-based visa for people with extraordinary ability in their field. So same language as the EB-1. It is employer-sponsored, but there is infinite more flexibility for the O1 than there is for other visa types like H-1B, L-1, E-2. There is sort of, the option for founders to use O1s as well as people sort of filing through agents on behalf of their own LLCs. So while it is not sort of a self-petition visa, there is a lot more flexibility for O1 as a visa. In terms of the sort of type of evidence, this is a really great question. And because, as you said, the O1A and the EB1A have basically the same criteria with a couple of minor tweaks in language and the fact that the EB1A has two additional criteria for art that are not in the O1A because they would be part of the O1B. However, in sort of practice, they are quite distinct. In my career, whether it's for sort of STEM or for academic biomedical researchers, very, very common to see O1s with only 3, sometimes 4 out of the total 8 criteria. That we have 3 or 4 and moderate to strong evidence for those 3 to 4 criteria. Those cases I see with good documentation and good, a good legal brief, very high approval rates for. Big difference there is that, for EB1A, I often looking for 5 or 7 criteria out of the 10, and we want to really make sure that these are super well documented.
Right.
So I think there is sometimes a conception, and I won't entirely say it's a misconception, but a conception that the O1A is like a path, is one half of the bridge, and then you kind of step onto EB1A and then you're in your green card. And I say it's not entirely a misconception because, even in the USCIS policy manual, it says, that the proof of documentation that an applicant has like an O1 is something to consider, but not determinative if they file for an EB1A. And, I know that a lot of practitioners feel very strongly that USCIS should give more weight to people who have an approved O1. And I absolutely agree. But it is important to remember from a sort of practical knowledge, practical experience that this is not how USCIS adjudicates these. And I can say from my experience that a starting entrepreneur or a earlier stage academic researcher, if you are looking for flexibility in your options, the O1 can be a really great visa option. But just to take care and remembering that is not necessarily, it may take a year or 2 years for that EB1A application to be ready after a successful O1.
And just to make a distinction now for our audience, I know that we're diving into a little bit more in-depth understanding of these visas, right? But the O1 is a non-immigrant visa, which means that you're not getting a residency, right? They give it to you for, typically the maximum amount is 3 years. You can renew it as many times as you like. And just like Andrew said, it could be a bridge, right, to the EB-1, but it's not a matter of fact that you're going to get an EB-1 just because you um, were approved for an O1. But you did mention something about, it's not particularly sort of like a sponsored. I mean, it is, but direct sponsorship, like say for if you were going to do a labor certification, right? And you did say founders, right? So can apply for it. And there's some flexibility. Can you explain a little bit about the sort of the structures that you've seen in terms of how basically people can be sort of petitioned, right? Or how you can do it, like through an agent? Can you explain what you mean that being petitioned by an agent? Can you give me examples if there's perhaps maybe a foreign entity or even an entity that has been created here in the United States where the person is the actual applicant? It might work, it might not work. That's sort of like self-petitioning, and that's not going to be allowed. And then when you're utilizing, I guess, the agents, an agent, I mean, how many sort of interested parties would you need, right? And I guess give a distinction as to if it's potential employers that they want you for a project for a like limited period of time, but they're not particularly committed in terms of sponsoring you. Can you just sort of dive in a little bit
Yeah.
into that and those the structures that can be utilized in order to have a person come in here under an O1?
Yeah. So as I said, and as you just laid out well, there is certainly a lot more flexibility in the O1. Traditionally it is literally petitioned by an employer. And so like, for example, for some really small founders, even if you have one other person like in the company, they can sign the forms, which would be much more obviously difficult of a hill to climb for example, an H-1B. In other instances, though, we can use an O-1 can be filed by an agent on sort of acting as the petitioner in behalf of the O-1 beneficiary. That's the sort of O-1 applicant. Now, in I actually find the sort of arts an easier way to think through this. This would be kind of in your traditional sense, like a photographer or a sound technician who's coming to the US on an O1 because they're going to work in multiple exhibitions or multiple movie projects. And so an agent is the person who actually files the O1, and then they document these sort of contract with details of each of these individual projects that they're going to work on. Now, an O1 agent can be filed that way. And as you pointed out, if you have sort of short-term projects, this can be a way to do that, to sort of have an agent file the O1 petition, documenting sort of these individual pieces of an itinerary so that USCIS knows that you have sufficient events or sufficient things to work on in your field of expertise. Now, an O1 agent can also be used a little bit more permanently in a sense of where an agent is the petitioner on behalf of a foreign company that cannot directly petition for an O1 in the United States because they have no US office. In that case, like a U.S. agent can petition for one of those, a foreign employee to work in the U.S. under O1. Some people may also use agents sort of as a means of self-employment in their field of expertise, even as an agent for an entity, means of a sort of full-time employment, but through an agency, because there's no sort of advanced company business structure. And it's important to remember that an agency agreement is very simple. Really, it's just someone. I mean, an agency agreement might be complex, but in theory, it could really, it's really just something as simple as the agent and the beneficiary sort of saying that they agree, the agent agrees to represent them or agrees to represent the foreign company for the purposes of an immigration petition. Any person who is authorized to be an agent can do this. So there's no sort of formal requirement that you find a real business agent, or that you find like, an agent in the sense of people who are movie actresses or others who have agents. Like, it's not that formalized, and that's something also important to remember.
So let me do a little bit of a follow up on that particular structure where you're dealing with the agent and say a foreign company. So would it be fair to say that, what you're doing there is that, and is an agent is doing sort of the petition for, on behalf of, sponsoring the employee of the foreign entity, and then the sort of the role of that employee is to sort of expand on what that foreign entity does overall, right, in their own country, whatever field that it may be, or do you see that you still have to tie it up to some sort of a prospective job in here, prospective clientele in here? How do you work that out?
That's a good question. Basically, we would need to still show in some way that the employee who is the agent is petitioning on behalf of is coming to the US to do work in their field of extraordinary ability. I think, logically, if we're filing on behalf of like a foreign employer, I think they're going to be here in some way that's benefiting the foreign employer. Like, I think for that agency agreement with the foreign employer to make sense. But, there's wouldn't necessarily need to be like a stepstone to like starting a US company that would then be like petitioning for itself. There's just a sort of need to show a concrete project or body of work that the O1 applicant is coming to work on in the US that requires sort of somebody at the top of the field.
That's great, and it's a good thing to remind the audience, at least for the O1, unlike EB-1 and EB-2, there isn't really sort of a number, right, of the amount of sort of applications that can be approved in a year, right? So it's there isn't that sort of I guess constraint or worry that there's going to be a cap or a long period of time. If you have the right criteria, right, and everything is aligned, then it should be a pretty straightforward process. But yeah, but I really appreciate the time, Andrew. I really enjoy our conversation. I think that you have given us a lot of light into some sort of topics that are not discussed, that when we everybody talks about the criterias, everybody can look it up on the internet, but I mean these nuanced things that only attorneys see on a day-to-day basis in their practice are very important to shed light to our audience as to what to expect and how to prepare themselves, right? Because what I always tell people that I work with is that in these type of visas, whether it be the EB-1s, EB-2 NIWs, or the O-1s, you can always work on your profile, right? So long as you're constantly working on your profile and you're doing projects, having in mind that this could be it's potentially a good evidence for a potential application, then the sky's the limit. You just got to work hard on your profile, and then you'll be in a position where you'll be able to apply for one of these visas and then come here to the United States. Any final thoughts on all these?
No, thanks, Joaquin. I really appreciate the time. I would echo and strongly agree with your last points that the legal regulations are, you can research them, but they're not always, it really is good to read and think about and, talk broadly about some of these things, because experience shows that, there's certain, that there are nuances and things that might not be what you expect from some of these visas in a good and bad way. And also, as you very well said, that, that these are things you can work and build on, and that it's certainly, visas that are, things to strive for in the sort of overall long-term U.S. immigration journey.
Absolutely. Well, Andrew, once again, I really appreciate your time. We're going to have more of these coming up. As I said, Andrew is extremely talented in what he does. We work with him, have a lot of clients with him, successful client as well that have been approved. And if you have any questions, by all means, please make sure that you reach out to us, and we'll be more than glad to have a second session where we can just discuss some of these questions that are more in-depth questions related to what we just spoke about. Well, thank you, Andrew, once again. Appreciate your time, and hopefully we'll be having a lot more of these in the future. Okay.
Yeah, thank you. It was a pleasure.
Sure. Take care.